Welcome aboard Rocket Ship, the platform with the most relevant content for competitive examinations. This is Rocket Ship IAS Lab and continuing with our series on answer writing for general studies papers of civil service main examination. We take up a question that you might come across in GS paper 2. Here goes the question. In what ways India's approach to affirmative action diverges from the approach adopted by the United States? Mention some recent developments supporting your arguments. Again, we are taking it for granted that most of you are aware of the concept of affirmative action, what it essentially means. As you can understand, in the case of India, it is observed mostly in the reservation system. Anyway, the question, as you can see in the question, that the second part of the question talks about the requirement of mentioning some recent developments. That is, you have to include some, you could say, current affairs, some news, etc., to bolster your points, as is customary with GS paper 2 questions. Anyway, we are introducing our answer with briefly going into the background of discrimination in the American as well as the Indian society, which has merited the concept of affirmative action in the first place. That is only due to this discrimination that some sections have suffered, that the affirmative action program is needed in the first place. India and the United States are the two largest democracies. Again, this observation does not need any, you could say, any argument to support it. For diverse regions, both India and US have large sections of their populations which have not only suffered oppression and discrimination, but also these sections are not adequately represented in public life. Again, the point is, there are sections in Indian society as well as in the American society which have been historically not only discriminated against, but due mainly to this discrimination, they are not adequately represented in the public life of these two nations, even till this day. Now, try to appreciate this basic difference, that in the case of India, this discrimination was based on internal stratification. Again, we are making a very important point, that in the case of India, the caste discrimination, the caste and Varn discrimination was based on internal stratification. That is, it was more oriented inwards. Where scheduled castes, scheduled tribes, and the backward classes faced many indignities and socio-religious disabilities. Again, you can understand that whatever disabilities that were placed on these sections had social, you could say, aspects as well as religious dimensions as well. Now, contrasting with India's case, in the US, the oppression is intimately connected to racism directed at Native Americans and blacks, who were subjected to unspeakable horrors, including enslavement. So, please, again, we would repeat it, that in the case of India, the caste discrimination is more internally oriented, while in the case of the United States, the racial discrimination is more outward oriented. That is, it is more towards the out group, that is, people who do not belong to the in group, that is the majority race. Affirmative action includes, briefly defining affirmative action includes policies aimed to preferentially treat hitherto deprived groups. This generally takes the form of quotas in public services and educational institutions, or for that matter, diluting the qualification requirements, either in public services or in the educational institutions, and so on. The three most prominent examples of affirmative action are those pursued by India, US, and South Africa. Again, this is a part of, you could say, general knowledge, that these three countries are well known for following the policy of affirmative action. That is India, the United States, and South Africa. South Africa, you can understand very well, it is mostly to you could say, deal with the effects of the apartheid system under which the majority blacks were discriminated against. In our case, this has mostly taken the form of reservations. Again, the point is, in the case of India, affirmative action is observed in the form of the reservation system. Now, again, this is another important point, that India enshrines affirmative action in her constitution going back to 1950 and takes a lead over the US, where it was brought into effect by an executive order of 1961. So please try to appreciate this, that in the case of India, the affirmative system, the affirmative action has constitutional backing, while in the case of India, while in the case of the United States, the affirmative action system is mostly an executive decision. However, the approaches diverge in fundamental ways. So what are the ways in which India and US diverge on affirmative action? First, as we have just talked about, that in the case of India, the affirmative action system has constitutional guarantee, but no such protection in the case of US. Then US approach leans more towards empowerment. India's approach is more comprehensive and includes adequate representation along with empowerment. So again, to briefly explain it, that US talks more about empowering the historically deprived sections through education, etc., through their participation in higher education, etc. But in the case of India, while India indeed talks about empowerment, India goes further and talks about adequately representing these sections in the public life, including public services, or for that matter in the educational institutions and so on. Again, in the case of India, the affirmative action has wider reach and it covers representation in democratic institutions as well. Like, for an example, reservation in seats for parliament, the legislative assemblies, the state legislature actually, as well as the local bodies. So the point is, in the case of India, we are taking affirmative action to the political realm as well, which is not the case in the US. Now, explaining these points, if we were to read into the articles, for example, articles 15.4, 16.4, etc., we observe constitutional sanction for affirmative action, placing it on a stronger footing, because the entire system of affirmative action has constitutional guarantee, it has constitutional sanctity, it is indeed in a strong position compared to the executive order, or like the executive order system that is the origin of affirmative action in the US. And again, we do not have to explain what article 15.4 and 16.4 do, but briefly, article 15.4 talks about a special treatment, again mostly special treatment, even going beyond the requirement of absolute equality for the benefit of scheduled castes, scheduled tribes, as well as the backward classes. And 16.4 talks about some form of reservation for these sections in the public services. Try to contrast this with the US system, where affirmative action is an executive program, easier to dilute, and it is indeed the case. This can be seen in the Students for Fair Admissions case of 2023, where the US Supreme Court has held the affirmative action based on race unconstitutional and mostly diluted the entire system of affirmative action. That is not going to be the case in India, because in India's case, the reservation system, the affirmative action system, has constitutional sanctity to a great deal. Sorry. The two countries had different objectives in mind. Again, US focuses on affirmative actions like diversity quota in college admissions as a means of empowerment, so that people are adequately, for example, skilled, or for that matter educated, so that they can come up to the general position, to the level of the general population. India goes further and includes the intrinsic value of a just and diverse society. Again, the point is India talks about not only the, you could say, the implemental value of the affirmative action, but goes beyond and talks about the intrinsic value of a just society and equitable society, etc. Therefore, we talk about adequate representation in public services and in wider public life as well. Again, this is a very, very basic point, and we have already discussed it, that the program has wider coverage in India, where affirmative action extends to reservation in political offices of parliament, state legislature, and even the local bodies. To briefly sum up, if we were to take into account, we would see that India's approach is more comprehensive. It goes beyond basic empowerment and even talks about adequate representation to be given to the hitherto less represented sections, the deprived sections. And again, please try to appreciate this. We have deliberately included this case law in the Janhit Abhiyan case of 2023. In the Janhit Abhiyan versus Union of India case, it was even extended to, that is, this system of affirmative action was extended to economic criteria as well. We would again, to simplify it, what happened in the Janhit Abhiyan case, in this case, the EWS quota, that is the economically weaker sections quota, was challenged, but the Supreme Court has upheld this provision of quota for the economically weaker sections. That means that in the case of India, the entire affirmative action system has evolved, and nowadays it goes beyond social discrimination and even includes economic deprivation. We would repeat it with the Janhit Abhiyan case versus Union of India. With the Janhit Abhiyan versus Union of India case, the entire affirmative action system goes beyond basic social deprivation, social discrimination, and nowadays it includes economic deprivation as well, which is visible in the form of the economically weaker section quota. So this was all on the difference in approaches regarding affirmative action between India and the United States. This is all for today. We would bring you another lecture in a few days. As usual, we wish you all the best. Thank you.